This will be part 3 of the introduction of the free Negro heads of families in the United States in 1830. Part 3. The free Negro before the law. The free Negro in the colonies was nominally, and in some cases actually, as much a part of the body politic as was the free white man. What few differences there were became more apparent in those parts where there were many poor whites emerging from indentured servitude and therefore finding it easier to associate with Negroes than with their former masters. Certain incidents of color, which marked the Negro as members of a decidedly different race, however, gradually brought into colonial custom and law some distinctions from which this class suffered only the more liberal attitude resulting from the struggle for the rights of man during the American Revolution. The status of the free Negro did not materially change for the worse thereafter until the 20s and 30s of the 19th century, when practically all of the southern and middle states and a few communities in the north began to restrict and in some cases to debase the free Negro to a status next to that of the slave. The transition, however, required some time. The feeling against the Negro in Maryland, for example, did not develop rapidly. Although the intermarriage of the races was prohibited there in 1663, and the measure was made more stringent by other acts in 1681 and 1717, the free Negroes could apparently vote and hold office there, for they were not legally deprived of this right until 1810. Virginia early endeavored to prevent the miscegenation of the whites and blacks, deprived the latter of the right to hold office in 1705, and prohibited them from voting in 1723. In North Carolina, the situation was more favorable to the free Negro, although the colony prohibited the intermarriage of the races in 1723 and 1741. The Negroes were permitted to vote there until 1835. During the colonial period, too, we find that the free Negro in Pennsylvania was subject to some of the regulations made for Negro slaves in the matter of trials and punishments. Prior to 1700, free Negroes were tried in the same courts in which white men were tried. Thereafter, they were brought before special courts only, although the law should have been legally applied to Negroes rather than free Negroes, but custom would have it as it worked out. Distinctions, too, were made in the penalties for murder, arson, burglary, or rape, all of which were punishable by death in the case of the Negro, whereas in the case of the white man, up to the year 1718, he would suffer death only if guilty of murder. To prevent vagrancy as a result of the increase in numbers, there was enacted in 1726 a law for binding out able-bodied Negroes who did not work. That same year, special penalties were imposed for harboring slaves, for the intermixture of the races, for frequenting tippling houses, for carrying arms, and for assembling in companies. The free Negro in that colony could not travel from place to place without a pass, and if his freedom was questioned, the burden of proof was on his side. The situation was better in New York than in Pennsylvania. It did not seem necessary to enact there so many precautionary measures as some other colonies passed. By the time of 1712, when the slave insurrection of that year frightened the people of the city and colony, however, the feeling against the Negro was intensified, and especially so in 1741, when several plots and conflagrations in the city were charged to slaves. Yet most of the restrictions in the colonial laws of New York referred to Negroes held as slaves rather than to those who were free. But with the increase of race prejudice, the latter suffered from the same discriminations. In Connecticut, as in New York, there did not develop immediately sufficient racial distinction to proscribe the free Negro rigidly, although slavery was recognized and protected by the general court of that colony. The same may be said of the case in the case of Massachusetts, in spite of the fact that the state prohibited trading with Negroes, mulattoes, and Indians in 1698, restricted the emancipation of mulattoes and Negroes in 1703 that they might not become chargeable, and prohibited their intermarriage with the whites in 1705. I'm going to read that sentence again. The same may be said in the case of Massachusetts, in spite of the fact that the state prohibited trading with Negroes, mulattoes, and Indians in 1698, restricted the emancipation of mulattoes and Negroes in 1703, that they might not become chargeable, and prohibited their intermarriage with the whites in 1705. With the exception of certain regulations for the return of fugitives and the like, free Negroes were not generally disturbed in the enjoyment of the fruits of their labor in New England, although they were not actually accepted as equals of the whites. During the colonial period, there arose in certain communities some fear as to what might happen in case of too many firearms in the hands of free Negroes whose contact with the slaves were unrestricted. They were therefore eliminated from the militia altogether, or, as in Virginia, for example, in 1755 and 1757, the free mulattoes, Negroes, and Indians belonging to the militia were were required to appear without arms. These measures, however, were decidedly modified, and some of them repealed altogether during the period of the liberal attitude of the patriots of the American Revolution. At first, there was a disinclination to enlist Negroes as soldiers in some of the colonies, and the Council of War decided not to accept them. When they got into a strait during the awful ordeal of the struggle, however, the colonies changed their attitude. Some of them enacted laws granting freedom to all Negroes who would don the colors, and cowardly masters were often willing to have their Negroes go to the front in their places on the same condition. Runaway slaves pretending to be free were sometimes accepted as soldiers. This was a new day for the free Negro. Some of the Negro soldiers in the American Revolution served in special units, whereas the majority of them went into the ranks side by side with the white companions. Virginia authorized a more liberal manumission of slaves in 1782 and proclaimed free all Negroes who had enlisted with the promise of manumission and had served faithfully. Rhode Island raised a regiment of slaves in 1778. New Hampshire liberated her slaves, enlisted Negroes, and gave to those who served 3 years the same bounty offered others. Connecticut did likewise in raising a Negro regiment in 1781, and Maryland undertook to raise 750 Negro troops the same year. Slavery was instantly abolished in some states. In others, it passed away by gradual emancipation. Thus encouraged, the free Negroes decidedly increased during this period, and there came, too, a change in the attitude toward this class. The very increase, however, was one reason why this did not long continue. Settling down to the problem of working out government in this country, the whites soon forgot the very distinctions against which they had so long fought and incorporated them into their state constitutions as they later incorporated them into the federal constitution in compromising with the less liberal states on slavery. There developed in those states in which the free Negroes were numerous a feeling that the rights and privileges of this class should differ from those of white persons. The states tended then to restrict the free Negroes to protect the personal rights of the whites and to prevent servile insurrection. Finally, an effort was made to stop the growth of the free Negro class or to get rid of it altogether. The regulations with respect to the free Negroes thereafter, therefore, tended to become almost identical with those of the slaves. Most of the states had restrictions having a direct bearing on earning a subsistence. Reading that sentence again. Most of the states had restrictions having a direct bearing on earning a subsistence. Statutes were enacted to prevent loafing and vagrancy. The children of indigent free Negroes were apprenticed to mechanical trades in some of the states. If a free Negro refused to work and become a public charge, there was usually some way of disposing of him by selling him into servitude for a certain period or into permanent slavery. The right of locomotion of the free Negro was generally restricted. While they remained at home among their neighbors, their freedom was not questioned, but in going from place to place, they were usually suspected and often imprisoned as fugitive slaves. If the victim claimed to be free, the burden of proof was on his side. In some cases, when moving beyond their neighborhood, they were reduced to the necessity of obtaining passes, very much like those issued to the slaves. But here they needed more. In hostile communities, they were compelled to secure from their manumitter or from a local official papers to the effect that they were registered as free. As such certificates could be easily counterfeited, free Negroes in transit through the country were subjected to all sorts of investigation. The penalty for counterfeiting such papers varied from heavy fines to imprisonment. The free Negro, moreover, gradually lost the right of assembly. It was early reported that the Negro assemblies were tumultuous and rebellious, and legislation to this effect may be found in the early statutes of the colonies providing for the flogging of Negroes found in such meetings. Later, the penalty applied, especially to free Negroes, was that of being fined and imprisoned. However, this did not generally apply to the assembly of Negroes for moral and spiritual uplift on Sundays. Some of these laws enacted by the states after the reaction reflect the spirit of the times. In 1805, Maryland prohibited Negroes from selling corn, wheat, or tobacco. In 1806, the state penalized the immigration of free Negroes. Negro evidence against a white man was prohibited in 1809, and in 1810, the race was disfranchised. In 1825, instead of merely imprisoning free Negroes for certain crimes, they were to be whipped, imprisoned, and then banished under the penalty of being sold as slaves for a term. Virginia prohibited the coming of free Negroes into the state in 1793, required them to be registered in 1800, prohibited them from carrying arms without license at the session of the legislature in 1805 through 1806, and in 1820 provided that they might be hired out to pay their taxes. North Carolina, which in 1777 had already proscribed free Negroes as witnesses, except in suits against each other, saw reason in 1786 to enact a law against the entertainment of slaves by free Negroes, and the intermarriage of slaves with free Negroes, except with the consent of the masters concerned. By a law of 1812, Negroes could not be mustered into the militia except as musicians. In 1826, there followed an act which restricted the right of the free Negroes to trade in certain articles and to peddle beyond their county without a license. That same year, the coming of free Negroes into the state was prohibited under the severe penalty of $500. As South Carolina, with the exception of Charleston, had never been very liberal toward the free Negro, there was not any possibility of much changing during this period. Georgia found it necessary in 1808 to provide for binding out free persons of color, roving about the country in idleness and dissipation. The state provided for guardians of free Negroes in 1810 and prohibited the immigration of others of this class in 1818. Florida prohibited the immigration of free Negroes in 1826, restricted the franchise to whites in 1827, and in the general Black Code followed the regulations of Georgia. Tennessee required the registration of free Negroes in 1806, forbade them to retail spirituous liquors in 1813, and prohibited the intermarriage between the two races in 1822. Kentucky, enacting in 1808 a measure to prevent the coming of free Negroes to that state, and another measure against conspiracies of insurrection in 1810, tended to take over the Black Code of other reactionary states. Farther south and west in the slaveholding territories where there was a much smaller free Negro population, it was not sufficient for the states of Alabama and Mississippi to follow the fortunes of the seaboard slave states in limiting the franchise to the whites and the like. Endeavoring to keep the free Negroes out altogether, these states added such other provisions as their development of the strictly slaveholding states required, and the number of free Negroes being thus kept down, the problem did not become acute in those quarters. In Louisiana, where under foreign control there had been an unusual race admixture with the free Negro on the basis of social equality, a different condition obtained. In spite of the rigorous treatment to which the slaveholding regime subjected the blacks, when that territory became a part of the United States, exceptions to the laws applied to free Negroes generally had to be made in the case of those whose equal rights and privileges were guaranteed in the Purchase Treaty of Louisiana in 1803. Yet we find Louisiana preventing the introduction of free Negroes in 1807 and restricting suffrage to whites in its Constitution of 1812. That same year, however, in the midst of the Second War with England, it authorized a military corps of free men of color commanded by whites. In 1815, another act allowed a police corps of free blacks in Natchitoches. By this time, moreover, the states to the north were solving the problem in various ways. In Delaware, according to the law of 1787, a manumitted slave could not vote or hold office nor give evidence against a white man, nor enjoy any other rights of free men other than to hold property and to obtain redress in law and equity for any injury to his or her person or property. In 1807, Delaware prohibited free Negroes from coming into the state to reside, forbade intermarriage of the races, and authorized the sale of free Negroes guilty of larceny. The Negroes in Pennsylvania, on the contrary, were nominally given all rights of free men in the year of 1780, when the act of the gradual emancipation of the slaves was passed. That year, the old laws were abolished and all restrictions apparently passed away. For the next generation, there seemed to have been little change, for as late as 1820, the state enacted a law to prevent the kidnapping of free Negroes. In 1798, New Jersey prohibited the immigration of free Negroes without a certificate and prevented free Negroes within that state from going from county to county without such a document. In New York, where gradual emancipation was provided for in 1799, the situation with respect to the rights of the free Negro was about the same as in New Jersey. Although the state enacted a law against the kidnapping of slaves in 1808, the second constitution of that state, which extended free manhood suffrage to the whites, barred Negroes unless they had property of the value of $250. Connecticut disfranchised the free Negro in its Constitution of 1818, and so did Rhode Island in 1822. In the states formed out of the Northwest Territory, where slavery was gradually eliminated by the 6th article of the Ordinance of 1787, there followed other measures which had to do with the restriction of the free Negro. This was especially true when they began to seek that country as an asylum from the oppression in the South. Ohio, for this reason, found it necessary to begin as early as 1803 to make distinctions between the two races. By its first constitution, the elective franchise was restricted to white persons. At the session of the first legislature convened under this Constitution, no free black was to be permitted to reside in the state except he had a certificate of freedom. Those remaining in the Commonwealth had to obtain such a document, without which they could not be hired by an employer, any employer. At the session of 1806 through 1807, no free Negro could come into the state without giving a bond not to become a public charge. By the same act, he could not give evidence against a white person. At the session of 1818 through 1819, however, there was some effort made to protect the Negroes against kidnapping, that those actually free might enjoy that status. Indiana prohibited the Negro from being a witness in a case in which a white man was concerned, proscribed the intermarriage of the races, required a bond of free Negroes entering the state, and later, by the Constitution of 1851, deprived the Negro of the right to vote and to serve in the militia. Illinois, in its first constitution, restricted the right of the franchise to white persons. In 1819, required a certificate of free Negroes entering the state. In 1829, exacted a bond of those desiring to settle and forbade the intermarriage of the races the same year. These restrictions were made still more rigid, and others of the most cruel sort were enacted during the critical period of the 20s and 30s. As slavery, in consequence of the Industrial Revolution, became an intolerable system of exploitation, Negroes here and there arose in servile insurrection. This fear was intensified by the Denmark-Vesey plot in Charleston, South Carolina in 1822, by the Walker Appeal, published broadcast to slaves in 1828, urging them to rise against their masters, and by Nat Turner's insurrection in Virginia in 1831. When the news of these movements was noised abroad, it struck terror to the very hearts of the slaveholders, forcing many of them to the position of going armed among their slaves and exercising every precaution against the free Negroes. The action of the various states during this crisis is illuminating. In the midst of this excitement, they resorted to further legislation. At the session of the legislature of 1831 through 1832, Maryland endeavored to get rid of free Negroes by a law providing for the removal of free persons of colors to Liberia. At the same time, it also forbade the immigration of free Negroes into the state and imposed many disabilities on the resident free people of color, so as to force them to go to Liberia. At the session of 1835 through 1836, Maryland made the printing of papers calculated to excite and create discontentment among people of color a felony and a high offense against the supremacy of the state. The following year, the navigation of vessels under the sole command of Negroes was prohibited by law. At the session of 1842 to 1841 to 1842, it was made a felony for a free Negro to call for demand. I'm going to read that sentence over. At the session of 1841 through 1842, it was made a felony for a free Negro to call for, demand, or receive abolition papers. The following year, the state prohibited the formation and assemblage of secret society of Negroes. And at the session of 1846 through 1847, more rigidly prohibited an admission of the evidence of Negroes in a case in which a white person might be concerned. In 1854, there followed an act imposing restrictions on free Negroes and their employers in their contracts for services. And in 1858, another measure to prevent free Negroes and slaves from having or using boats on the Potomac River. Virginia responded to the spasmodic appeal for drastic action. At the session of 1830 through 1831, the legislature prohibited meetings for teaching free Negroes or mulattoes to read and write, penalized whites for holding meetings with Negroes, and proscribed assembly with slaves for such a purpose. That very next year, this legislature brought out new enactments against preaching by slaves and free Negroes, and against slaves attending any preaching of a white minister at night without written permission. It was provided that no free Negro or mulatto should be capable of purchasing or otherwise acquiring permanent ownership, except by descent to any slaves other than his or her husband or wife and their children. For writing or printing anything advising persons of color to rebel, a severe penalty was imposed. In 1834, the restrictions of intermarriage were made more rigid. In 1836, there followed a special act to suppress the circulation of abolition literature for purpose of exciting the Negroes to rise against their masters. And in 1838, free persons of color leaving the state for the purpose of education were prohibited from returning to that commonwealth. The life of the free Negroes having thus been made almost intolerable, the state established in 1833 a colonization board to be supported by a poll tax on free Negroes to deport them to Liberia. In 1856, it enacted a measure providing for voluntary enslavement. Following the wake of these other states in 1831, North Carolina enacted a measure prohibiting free Negroes from preaching. Its new constitution, adopted in 1835, limited the franchise to free white men. In 1838, the state declared void all marriages between white persons and Negroes of free persons of color or free persons of color to the third generation. In 1840, free Negroes were forbidden to wear or keep bowie knives and the like without having obtained a license. In 1858, there was enacted a measure for the hiring out of free Negroes in the discharge of fines, and by the same law, they were prohibited from selling spirituous liquors. Tennessee, from her point of view, thought it necessary to forbid the immigration of free Negroes in 1831, to prescribe the intermarriage of the races, and to prohibit emancipation except on bond being given to remove the emancipation out of the state. Its Constitution of 1834 declared that all free Negroes should be exempt from all military duty in time of peace, and also from paying a free poll tax. At the session of the legislature in 1855, through 1856, free Negroes were forbidden to peddle or barter market stuffs. In 1854, the state provided for the transportation of free persons of color to the west coast of Africa, and in 1857 for the voluntary enslavement of free persons of color. South Carolina, too, which had already a sufficiently stringent black code to meet all demands, nevertheless reflected the excitement with a measure of 1831 prohibiting Negroes from the manufacture and the selling of spirits. In 1834, it prohibited not only the teaching of slaves, but the employment of a colored person as a clerk or salesman in any shop, store, or house used for trading. In 1844, it prohibited for the punishment of persons disturbing the peace of the state in relation to slaves or other persons of color, an act which decidedly restricted the social privileges of the free Negroes. Georgia, equal to the occasion, too, supplemented her black code in 1829 by prohibiting the employment of slaves and free persons of color in the setting of types in printing offices. In 1833, they were prohibited from preaching and from carrying firearms. In Alabama, the excitement culminated in the enactment of a law in 1832 prohibiting the settling of free persons of color in that state, penalizing the teachings of slaves or free persons to spell, read, or write, preventing the writing of passes and Negroes from preaching. In 1852, free Negroes were forbidden to sell liquors, and the appointment of guardians for them was authorized. Mississippi responded in 1830 with an act providing with punishment by death for persons of color circulating seditious pamphlets. They could not be employed in printing offices, nor could they keep a house of entertainment. Free Negroes were prohibited from immigrating into the state in 1843 under penalty of being sold, and an owner could not liberate his slaves without removing them from the state. Louisiana deemed it expedient in 1830 to enact very stringent measures. These dealt with the coming of free Negroes into the state, the writing, printing, speaking, or publishing of what they considered seditious pamphlets, the prohibition of the teaching of free Negroes or slaves, and the prevention of manumission except on the condition that the emancipated be removed from the state. Finally, in 1859, the state, like some others, provided for voluntary enslavement of free Negroes. Florida enacted measures very much like that of these other states, although it did not act so promptly as the states which were apparently more alarmed. These measures covered the restrictions upon manumission, then the prohibition of the intermarriage of the races, the selling of free Negroes for fines against them, the prevention of their immigration, the provision for the guardianship of free Negroes, the penalization of the sale of drugs to them, and the act for their voluntary enslavement. As the institution of slavery had about passed away by gradual process in most of the northern states at the time of Nat Turner's insurrection, the precautions required in the economy of the South was unnecessary in the North. These states, however, were unusually frightened by the increased immigration of free Negroes into these commonwealths. Thinking that they might be overrun by such a population, many of the northern communities became arrayed against the free Negroes already resident, and especially against those seeking refuge from oppression in the South. Pennsylvania, then a place of frequent race riots resulting from this influx of free Negroes, easily became induced to provide for the disfranchisement of Negroes in the new Constitution framed and ratified in 1838. In 1823, New York restricted Negro suffrage to such persons as owned $250 worth of property. New Jersey confined suffrage to whites in its Constitution of 1834. Connecticut, having already done this in 1833, was moved by the fears of the influx of the Negroes to take more drastic action because of an excited multitude at Canterbury in that state, where Prudence Crandall decided to admit Negro girls to her school. Connecticut enacted a special law prohibiting such an institution from admitting free persons of color from outside of the state and imprisoned Prudence Crandall under this law when she dared to violate it. In other free states of the West, there was also some evidence of this fear of the influx of Negroes, sometimes culminating in riots. But not so much legislation followed for the reason that most of these cases had already been provided for in their respective black codes. Indiana more rigidly expected Indiana more rigidly exacted a bond of Negroes and mulattoes coming into the state for permanent residence, and so did Illinois in 1829 and in 1831, making this more stringent in 1853. Michigan's Constitution of 1835 limited the elective franchise to the whites. On the whole, however, the fear excited by the insurrection among Negroes was easily abated by the failure of such insurrections and the increasing interest of Northern agitators in the abolition of slavery. During the 30s and 40s, there appeared at various points persons in the leadership of ardent abolition like William Lloyd Garrison, Wendell Phillips, and Frederick Douglass. Making such a good case for the Negro, they tended to excite sympathy for the fugitives. When the South, in its aggressive attitude in the recapture of fugitive slaves, violated certain principles of liberty so dear to those who remembered the struggle for the rights of man during the American Revolution, the northern states became still more sympathetic. They enacted measures against the kidnapping of free Negroes and passed personal liberty laws guaranteeing them the privileges of the writ of habeas corpus, and the right of trial by jury. These measures, however, were nullified by the Fugitive Slave Law of 1850 and the Dred Scott decision. On the whole, however, there was a striking difference between the status of the free Negro and that of the slave. The free Negro gradually lost ground during the reactionary period, but he did not become as helpless as the slave. The free Negroes still retained their right to acquire and dispose of property, and to do so could employ the general means affecting the transfer of property. The courts early upheld the right of the Negro to devise property to another. Laws to this effect were enacted, as were also other measures to validate titles to real estate and other property, with the exception of dogs and guns mentioned above. Russell points out that the inviolability of the property rights of the free Negro was an effective argument against the frequent proposals to move the entire free Negro population from Virginia. It was considered a hardship to bring their property into market all at once to be sacrificed by one precipitate sale. This right to own property extended even to that of owning a white indentured servants and slave. Early in the history of the colonies, as in the case of Virginia in 1670, Negroes and Indians were prohibited from owning white indentured servants, but were still permitted to acquire property in persons of their own color. This right to own Negro slaves remained until the reactionary period incident to the fears arose by Nat Turner's insurrection during the 30s. However, in certain parts, it was never taken away. The reason for the change in attitude was not only that the whites were desirous of maintaining slavery as the normal condition of the blacks, but particularly because free Negroes, for benevolent reasons, often purchased members of their family that they might thereafter be manumitted for a nominal sum. An effort was made to prohibit this by restricting manumission, but free Negroes thereafter continued to purchase their wives or husbands or children and to hold them in slavery since they could not manumit them if they were to remain with them. A man therefore often purchased his wife, or the wife her husband, and or the wife her husband, or the parents their children. This led to unusual complications upon the death of the free owner if he died intestate. If there were no relatives legally qualified to receive the inheritance, such property escheated to the state, inasmuch as slaves were not considered as persons before the law. Permitted to own property, the free Negro could not escape the burden which was imposed upon property owners. In fact, instead of being exempt from taxation, the free Negro was sometimes required to pay a higher poll tax than the white man. The position taken was that although the free Negroes should not be allowed all the privileges of the whites, they should still be held as liable to carry their part of the burden of the state. There were some exceptions in this case, as it happened in Virginia in 1769, with the exemption of free Negro, mulatto, and Indian women, and all wives other than slaves of free Negroes, mulattoes, and Indians. This, however, left the male free Negro subject to the payment of the same taxes collected from the white man. Virginia made further discrimination in capitation taxes in 1813, when it laid a special poll tax of $1.50 on all free Negroes above 17 years of age when not bound out as apprentices. The idea here was not so much to increase the revenue of the state as it was to get rid of this class of population. However, the records show that the Negroes generally met this obligation and thereby made it impossible for any large number to suffer the penalty of being reduced to a state of servitude. Virginia imposed on the Negroes a special tax to raise funds to deport them to Liberia, but used most of this money for other purposes. The Negroes in Baltimore paid $500 in school taxes in 1859, although their children could not attend the city schools. And that marks the end of part 3 of the introduction, the Free Negro before the law.